Hello, everybody. Welcome to our morning break, L&J's morning break. We're really excited about this. Glad you're here. We'll have a few more join us. Thanks for giving us 15 minutes of your day. We're planning on doing this every week on different topics. Next week, we're thinking about business issues, meetings, and dealing with vendors and all of this nonsense going on. But we're thrilled you're here. Let me introduce a couple of people. Today's morning break is going to be on dealing with assessments in this nonsense time period, crazy time period. And we've got Jeanette Shockley, Dan Wright, and Brad Griffin in our group are going to talk today. If you're not familiar with the GoToMeeting format, there's a spot where you can ask questions. You'll see it on your sidebar. We won't answer those now, but if you send them, we're going to get back to everybody with your individual questions. And if you have topic ideas for future ones, let us know. Just shoot us emails. You guys have my number. You can call or text me or email me. So we're thrilled to do this. We hope everybody is staying safe. Be careful out there. And we are going to start up with collection issues. Thanks for joining us.
Okay, so Jay is much better at looking into the camera than the three of us probably will be. So bear with us. I wanted to say good morning to everyone and thank you for sharing a morning coffee break with us. You know, we miss seeing you all in person and we wanted an opportunity to connect face to face so that you could see us and, you know, we can have some sort of normalcy during this time. And I think everybody appreciates the comfort of a familiar face, even if it is mine, Dan, and Brad's. So in times like these, we think it's best to have the facts and to have a plan and a way forward. We've put this short program together to keep you updated on the impact of COVID-19 on collections and how to proceed with collections conscientiously in light of everything that's going on in the world while still making sure that we're protecting the association's interests. Dan, can you talk about the Georgia court's response to the pandemic?
Sure. As we know, the pandemic has caused emergency action basically all across the nation and has affected all industries. Legal industry is no different. In response, specifically in Georgia, in response to the pandemic on March 14th of this year, the Chief Justice of the Georgia Supreme Court entered an order declaring a judicial emergency. This is a very rare event and has caused a lot of confusion across the industry. In the original order, it was supposed to go to April 13th. However, it was extended by another order that extended it through May 13th. So we still have a ways to go. We're not quite to the end of it yet. As I said, there's a common misconception at this point that the courts are shut down, and that is not really the case. The courts are a little more limited and a little more restricted in what they can do, but they are pretty much going to the best of their ability, and we'll cover some of what's going on now. Really, what the order has done is told or paused the time for defendants or the owners, in our case, to respond to lawsuits and motions. But other than that, the courts are pretty much operating as normal as are we at L&J. Basically, when the order expires is when things will really start to kick back into the normal mode. However, I did want to let you kind of know what this means for you. Essentially, everything, if the owner had filed or had been served, I want to give you an example. If the owner has been served prior to the entry of the order and their time to respond or their time to file an answer ran before the March 13th order went into effect, we can still get our judgments as to those owners, and we have been doing that. So you probably have seen some orders coming through and some judgments coming through as you normally would. But as an example, if a defendant was served on March 1st, typically, as you know, they have 30 days to file an answer. So what happens if the order was entered on the 13th? As of that date, it paused. So they would still have 18 days to file their response once this order is lifted or once the order expires. And statute of limitations are similarly told. So they were also told, so if the statute of limitations on something ran after May 13th or after March 13th, it's also been told. And we will have some time period, although the court really hasn't specified as much on statute of limitation as they have on times to answer how it's going to affect us going forward after the expiration of the order. But what does this mean for the association and for managers? You can and still should turn owners over for collections as you normally would, and we'll talk more about that a little bit later. Obviously, there are some concerns as far as being a little more lenient, possibly, given some of the effects that it's had on some of the owners out there. There is good news. The good news for owners, we can still send demands, make calls, file lawsuits and motions as we always have. So if that's been your concern about turning owners over, don't worry about that. We'll get that going. We can also get judgments, as I said earlier, for things, owners that may have gone into default prior to the order being entered and or responding to a motion for summary judgments, for instance. We can still get those judgments. So also we have also recently started having some court hearings in a similar method to what we're doing now, by Zoom or GoToMeeting or Teams, whatever the specific court has started to use. So there are still some court cases that are trickling along, and mainly those have been bankruptcy cases that are being done telephonically or damages hearings for owners who are already in default. But it is helping that it's moving some of those cases through, so maybe the backlog won't be so great once the order is lifted. The garnishments that were filed prior to the entry of the order also are still being paid into the court. So that is still good news that we are still having some of those funds that were garnished for garnishments filed and served prior to the order being entered. Those are also trickling into court, and we are getting some of those checks. Not as many checks as we would like right now, but we're still getting answers and payments into the court on those garnishments. Bad news is that we have to wait for judgments and orders on cases where the owners were not served or not in default until after the order was entered. Again, that operative date is March 13th. So if they were served or they still had time to respond prior to the entry of that order, they're still going to have that same amount of time to respond that they would have had when the order was entered on March 13th after the expiration of the order. So if, again, just as an explanation, how that's going to work is if they say they had 18 days to respond on March 13th, they'll still have 18 days to respond once the order is lifted. So at that point, we'll pick up where we normally would and file motions for default and go from there after this confusing time when the order is lifted is finally takes effect. We think that it's going to be May 13th at this point. Haven't heard a whole lot about the order being extended, but there is still obviously plenty of time for them to extend that order if needed. The other bad news is on garnishments. Even though we can file garnishments, all courts, to my knowledge, none of them are filing or serving garnishments. So even if a garnishment's filed, it's just sitting in the clerk's office, which causes numerous problems. And logistically, we have felt it better at LMJ. Even though we're still preparing garnishments, we are not filing them yet because we don't want them to sit and go stale in the clerk's office. So that's kind of the overview of what the judicial emergency order means for us and for you. Hopefully that makes sense. If you have any questions, please feel free to send me an email or send the chat, and we will get those responses back to you as soon as we can. With that, I'm going to turn it over to our moderator. But good to talk to you. Hope everybody's doing well, and hope to see you in person soon.
Brad, you're up.
Oh, well, I thought a moderator was coming in. I was excited to meet him. So Dan's done a great job of laying this out with what's happening in the courts, but what I think is most important is to not let the information about where the courts are and what decisions the courts have made stop or scare a board from making decisions and moving forward here. We've all heard before, the right decision is oftentimes not the popular one, and that's going to ring true for a while right now. We know that when people experience financial hardship, many of them prioritize their expenses, as we all do. But for some reason, we all see that association assessments oftentimes get a low priority in those situations. What I would want to stress to boards particularly is that any forbearance or delay in existing schedules or collection policies, when you take it as a broad sweeping change, it communicates to the membership that the association or the board essentially agrees with the idea that they are a lower priority or that they can wait for their money while others can't. When in fact, we all know many associations cannot wait for their money as their monthly expenses are continuing ongoing and they haven't changed during this. And as I briefly stated, you want to avoid the sweeping changes because you got to keep your eye on the road ahead. This current situation will pass. Things will begin to return to what we will recognize as a new normal. But there will be delinquencies that result from this. And there will be ripple effects that result from this for months to come and perhaps into 2021. But what we don't want to see is a repeat of the 2008 crisis where associations either deferred on collections or refrained from taking action early and found themselves in a position where they couldn't afford to go pursue delinquent owners. The likelihood of seeing that again for some associations increases exponentially when a board opts to kick the can down the road. And this isn't all to say that an association should be unsympathetic to people in this hard time. And while many are experiencing hardship, there are many that are in fact not experiencing a hardship per se. That's where a sweeping or a broad change to the association's assessment policy will result in a disruption to the association's assessment income. And while concessions and negotiations should be addressed on a case-by-case basis, which allows the association to mitigate the disruption in its revenue, but also give those owners that are experiencing a hard time and need a little bit of help to give them that attention to help them. But in a nutshell, it means collecting assessments on time from those that can pay, and it allows the board to look at those that cannot with the specific set of circumstances. Dan had mentioned that we hope that this technology and these video hearings are going to keep the court's backlog to a minimum, but we do expect some level of a backlog when we return to normal. Where that really has an impact is that an association that has delayed its collection efforts or restructured its policy also is delaying getting into the court system, which means they're going to come in behind the backlog. And we don't know what that backlog looks like. It may be negligible, it could be substantial. And then two parting points I think that are important here is pool season oftentimes motivates delinquent owners to resolve their accounts without the association ever having to take legal action. At this point in time, there's little to no guidance on what pool season will look like this year for public pools. So one built-in collection tool may or may not be there that has otherwise been available to the association. And at the end of the day, like I said, I don't mean for my position to sound insensitive, but board members must understand that they have a fiduciary duty to make decisions that are in the best interest of the association as a whole. And that means taking steps, even when unpopular, to secure a level of certainty for its revenue stream so that it can survive this and continue to move forward. Jeanette?
I had to smirk when you were talking about being sensitive. Sorry, Brad.
I struggle with it.
I know. You know, we all want to be sympathetic to our neighbors, and everybody is affected by what's going on out there, either directly or indirectly. It's a balance for the boards. You know, if you swing too far one way and say we're not going to do anything, that's not the best reaction. Obviously, if you swing and you go super aggressive and don't acknowledge that obviously there's some situations going on, outside of, you need to pay your dues and mow your grass, that can lead to problems itself. So we really want to make sure that we are promoting kind of what I'm calling conscientious collections. So you're aware of what's going on. We're doing the things that we need to do to protect the association's financial interests. And you're balancing that with the fact that people are going through things, and there are ways to have a middle ground in that. So I do think it's very important to start accounts in collections. You want to make sure at this point all of our associations have their lien rights secured. There's a lot of people that are refinancing because the rates are very low right now. We've gotten a bunch of payoffs in the last couple of weeks, big chunks of money for the association because people are refinancing and they're able to roll that in. And they're taking advantage too that the housing market is still pretty high. So some of them have additional equity that they can use to pay off association liens. So that's something we want to keep in mind. We want to get in there early to secure the amounts owed through a lien. You also want to have that for bankruptcy. We may see a rise in bankruptcy filings as a result of everything that is going on right now. And having a filed lien in the records is the best way to be secure in a bankruptcy, so that either you get paid in full, hopefully through a Chapter 13, or your lien survives a Chapter 7 discharge. I wanted to kind of circle back and give everybody a little bit of updates on different changes in legislation and some new orders that the governor has recently handed down. Just last week, the governor authorized remote notarizations. So what that means is when you guys get those somewhat annoying and pesky verifications and affidavits from us that you have to sign and get notarized, you don't have to now leave your home to do that. The remote notarization allows us to connect on something like this format, GoToMeeting or Zoom, so that we can see you and we can talk to you. You can show your ID and sign in front of us and a notary, and the notary can then, affix their seal to it that same day. Something that is important to keep in mind, though, about that order is that it does require that the notary be a Georgia licensed attorney, or the notary has to be supervised by a Georgia licensed attorney. So if you have a notary in your management office, but obviously you don't have a licensed attorney standing over them, there is a question of whether or not that complies with the order. So I would just encourage you guys, if you can't get out and get it notarized or don't want to go through that hassle, let's definitely take advantage of that right now. It's, super easy. We're happy to set up meetings with you to get you signed in front of us, and have one of our notaries finish everything out. So whatever we can do to make sure you're safe, and make it more convenient for you so that we can keep business running in new and different ways, we're happy to do that. So that's just a little bit of what's going on out there in the latest news.
Awesome. Thank you, guys. Thanks for joining our morning break. Hopefully you make the others. Obviously, this is a crazy time, and there will be people who have legitimate issues, financial issues because of this. And we need to be generous and accommodating. But we also know that so many of our people are going to be delinquents, whether this COVID issue arose or not. And if we, as everybody talked about, if what we do is just wait until the swarm all starts up again, it's going to be just devastating to all our communities how slowly it moves then. So it's important to keep going with people who we know are honest, legitimate delinquents who really should be paying. I think that's the message. We hope you all stay safe. We hope you let us know if you think of other questions, and we will get back to some of these individual questions we've received separately. We love you guys. Hope to see you all soon. Take care.
Go Dogs.